Hi, I'm Simone Green. I'm an Accredited Specialist family lawyer with Russell Kennedy Lawyers. Today I'd like to tell you about some very important changes coming about on the 6th of May 2024 to parenting matters. In this video, I'll briefly explain the best interests of the child principle and changes that are being brought about by the amendments. The best interest of the child is the paramount decision for the court when making any parenting order. Nothing's changed there. So what do these amendments do? They simplify the amount of considerations a court must do when making a parenting order to ensure that any order is made in those child's best interests. Prior to the amendments, the court was required to consider 2 primary and 14 additional considerations when determining whether an order was in the best interests of a child. Now, this has been simplified to 6 general considerations. So what are those 6 general considerations? The first is safety. Now, safety of a child used to be one of the primary considerations prior to the amendments. Being part of 6 general considerations doesn't mean that the court will not take the safety of a child as paramount. It goes to the very core of what is in the best interests of a child to ensure that any order made for a child promotes that child's safety and the safety of anybody caring for that child. Further to this is a requirement that the court must take into account any past or present family violence orders that apply to that child or a member of that child's family. Children's wishes. Now, children's wishes have always been important, but they are not the deciding factor when making court orders. Children's wishes will be considered amongst the range of factors that the court must determine when making a parenting order. These amendments change the wording, and there is no longer a need to balance the child's wishes against their age or level of maturity. In essence, this slight change of wording won't really affect much. The court will still consider any wishes expressed by the child, but holistically against all of those other considerations. The needs of the child. While the wording of the amendments might have been altered, the effect hasn't. The court is still required to consider the developmental, physiological, emotional and cultural needs of that child before making an order. Capacity. The court needs to consider the capacity of each person who has or proposes to have parental responsibility for a child, including that person's ability to provide for the developmental, emotional, psychological and cultural needs of that child. Benefit. The court will need to consider the benefit to a child of having a meaningful relationship with both of their parents when it's safe to do so. There's also a catch-all provision that allows the court to consider any other relevant circumstances when making a parenting order. There's also a standalone provision for children of Aboriginal and Torres Strait Islander background. The court must consider the impact of any proposed order on that child's right to enjoy connection with their culture. Key points to remember. The amendments take place on the 6th of May 2024. They'll apply to all new and existing cases before the court. The best interests of a child are still paramount. There has been a simplification of the considerations. If you have any questions about how the amendments will impact you and your family, call Russell Kennedy Lawyers today and let us guide you through. I've been Simone Green, an Accredited Specialist in Family Law from Russell Kennedy Lawyers. Do not hesitate to reach out if you have any questions concerning this video.